This video is going to cover lease clauses. The first clause is called condemnation. There's two scenarios. One is a government entity has deemed a premises uninhabitable. In that case, the tenant has a right to automatically terminate the lease. In the second scenario, only a portion of the premises has become uninhabitable and the landlord continues to charge the full amount of rent for the premises. The tenant could then seek damages from a court for having to pay the full amount of rent, even though they don't get to use and enjoy the entire premises. The next lease clause is called a compliance clause, and that identifies which party has to comply with any new local, state, or federal law, including the Americans with Disabilities Act. The next clause is called a substitution clause and allows the lessor to substitute a like premise when the subject property has become uninhabitable. Under the tenant improvement clause, it details what modifications are allowed to be made and who pays for them. It also restricts the tenant from making those modifications without written consent from the landlord. If the tenant is authorized to make modifications and hire the contractor themselves, there's what's known as a notice of non-responsibility, which would be posted by the owner to inform a contractor that if the tenant hires them, the contractors go directly to the tenant to seek recourse for any non-payment. They cannot file a mechanics lien on the property. We have a memory aid so far. It's the term cost. C is condemnation. O is occupancy compliance. S is substitution. And then T is tenant improvements. You want to think about what is the cost of changing or losing your lease space. Here's a visual chart on that. Under condemnation, it's either partial or full condemnation by a government entity. Occupancy compliance is following ADA, zoning, and safety laws. Substitution is the landlord's relocation of the tenant space. And then under tenant improvements, it's customizing and remodeling the interior. The next lease clause is called quiet enjoyment, and that infers the exclusive right in possession and use of the space, and it should include a clause for the lessor when they're showing the property to prospective buyers and lessees what those inspections rights are, and that they have to be made during reasonable hours at a reasonable notice. Memory aid for that is peace. Possession, which includes exclusive right to hold and use the space. Eviction protection, you can't do what's known as a constructive eviction by shutting off utilities or locking them out. Access, the right to get in and out with unreasonable barriers. C is the comfort and use the space is fit for its intended purposes. And then E is exclusion, the power to keep the landlord and others out without notice. And the mental hook on that one is the covenant of quiet enjoyment guarantees my right to peace in my own space. On the retail side, we have a clause called recapture, which allows the lessor to take back the lease space not used by the lessee in an assignment and a sublet lease. And think of capturing a prisoner. If the tenant tries to hand off their space to someone else, the landlord swoops in, recaptures the space, and takes it back for themselves. Under a relocation clause, it allows the lessor to relocate a tenant to a less desirable location in a retail, let's say, mall scenario, if they're not meeting sales plateaus. Think of real estate musical chairs. The music stops and the landlord forces you to pick up your store and move it to a different seat in the mall. Under a non-compete clause, it restricts the lessee from opening up another store within an agreed upon distance from the rented out location, but it also protects the tenant from having another space move in that's a similar or the same business. So the memory item on this one is think of no neighbors allowed who sell the same thing. If you open a coffee shop, the landlord can't let another coffee shop open up next door. Final memory aid is R&R, recapture, non-complete, and relocation. So just ask yourself on a commercial lease, what is the landlord's R&R strategy? Are they recapturing empty space? Are they protecting against non-competes? Or are they relocating a tenant to maximize the layout? Best of luck, as always, in studying for your exam.